Hello, I'm Ronnie Eldridge. Welcome to Eldridge and Company. The Patriot Act was recently reauthorized, quite quietly, I think, but was it improved? I've asked Melissa Goodman, an old young friend of mine, and the National Security Fellow at the American Civil Liberties Union, to tell us what she's found. So welcome. Was there a lot of debate about the Patriot Act?
There was a lot of debate, but unfortunately the debate was quite lopsided. And one of the reasons is that because of the secrecy that's built into a lot of the Patriot Act provisions themselves, the people who have the closest kind of first-hand knowledge of how the government has been using the Patriot Act are gagged from speaking about it and speaking about their experiences.
So being gagged means it's a court order that they can't talk publicly?
Unfortunately, it's not even a court order. To give you an example, there's a provision called the National Security Letter provision that was enacted originally with the Patriot Act. What the FBI can do through these national security letters is issue a demand to internet service providers or libraries and can demand personal sensitive customer information about their customers without any court approval. They do it unilaterally. And each one of these demands comes with a gag. So if you are an internet service provider, you get one of these, you can never tell anyone anything about it. Some of that was recently changed, but in the course of the debate, the people who had received these demands couldn't, come to Congress and talk about it. So unfortunately, I think a lot of the debate was actually very lopsided.
You represented some of the librarians, I think, from Connecticut. There's a case, right?
There are two national security
challenges.
Letters.
Yes.
And unfortunately, I'll just say at the outset that because of that, I'm actually still under a number of gags, so there are some things I can't say. But there were actually two cases. One case that we brought was here in New York, which was actually on behalf of an internet service provider who received one of these NSLs and was very brave and came forward, because the law as it was written then, it didn't even say you could come and speak to an attorney. It just said, do not tell anyone ever that you have received this.
And that means that the provider can't tell the individual that there's a surveillance going on or anything like that.
You will never know that your records have been asked for by the FBI at all. So he came to us, and we actually filed a challenge on his behalf, actually challenging also the constitutionality of that whole statute. And we actually won that. A judge in New York struck down the statute, saying that the gag that it was imposed was unconstitutional and that there were various other constitutional problems. In the meantime, we also filed another case that was a bit more narrow on behalf of, this is still all I can say, an organization with library records received one of these demands. And we also filed a similar challenge. But because the Patriot Act debate was in its throes, we said, let's move quickly and try to ask a court to lift part of the gag, to at least let the people who had received the letter to disclose their identities. And we actually won that as well, which you would think would mean that they could come out and talk, except the government fought that very, very viciously, might be a word. And so the Second Circuit imposed what they call a stay, and it meant that the clients could still not talk.
During the debate on the bill.
Exactly. So we asked the Second Circuit, the appeals court, to act quickly to lift the gag. They hadn't acted yet, and in the meantime, the Patriot Act was reauthorized. So
the gag means that the FBI could come to the library here at the Graduate Center and subpoena the records of a student or a faculty member, right? Mm-hmm. What books they've read. It means the librarian can't say anything to anybody that they've received this gag order.
Right. I will say that the law has changed a little bit.
Now the law has changed so that somebody is able to have counsel, but who is it?
What the law says now, and to answer the question you first posed, which is, does it make it better? It actually does not, and in many instances, it actually made it worse as a constitutional problem. What's different now is now, say this library, you posit, gets a national security letter. The law says you can now tell an attorney or those who are necessary to, comply with the demand.
The person who gets the gag order.
The person who gets the gag order. Again, the person whose records they're looking for will still never be told. Never.
Never.
And one thing that did change is that the person who gets one of these letters can now go into court and challenge the gag.
Giving the information?
They can, yes, they can challenge both. They can go in and a court can say, you know, it's unlawful, they don't have to turn it over, or they can come in and challenge the gag. The problem is that in the realm of First Amendment, you know, law, usually before some kind of gag is imposed on you, a court has to impose it, not the government by itself. And the burden should never be on you to go into court and spend the resources to try to get out from under it. And even the new law is bad in the sense that when you go to court, the standards that the court has to apply are supposed to be normal First Amendment standards that are very high, a very high hurdle for the government to jump over. That is not the case here. The judge can only set aside the gag if he or she finds there is no reason to believe that disclosing the information will harm national security. Now, normally you don't get to gag people or infringe First Amendment rights just because the government might believe there's some reason, you know, some harm that might, you know, happen. They have to show there's a compelling interest and, you know, they're gagging the least information possible. So it still doesn't meet constitutional standards.
It's really a scary kind of thing.
It is.
Now, there are a couple of other parts of the Patriot Act that I think you're working on challenging. One is the, what do they call it? The ideological
Exclusion provision?
Exclusion provision.
Sure, I can talk about that. When the Patriot Act was enacted, they also changed some things about immigration law. So this is totally different than the surveillance things. They added to the law a provision that says anyone who used their position of prominence to endorse or espouse terrorism could now be barred from the country. And we believe that they have used that provision to bar a particularly prominent Muslim scholar who's in fact the most prominent Muslim scholar in Europe, who actually has never endorsed or espoused terrorism, and quite to the contrary, every public statement he's ever made denounces terrorism, to the extent that Tony Blair, he now teaches at the University of Oxford. He was prevented from going to teach.
Notre Dame.
Yeah, he had a position there, and the government revoked his visa, pointing to this endorse or espouse provision as the explanation for it. But with that aside, he ultimately got a job at the University of Oxford right now, and Tony Blair actually appointed him to a special task force to fight extremism. Yet our government seems to... Yeah, we've excluded him. The law has actually been made even worse since the enactment of the Patriot Act. Another law, I believe it was in 2005, made it broader. Now it's any person, doesn't have to be a prominent person, who endorses or espouses terrorism or persuades someone else to endorse or espouse terrorism can also be barred.
Now, do they have an appeal process?
Actually, in that case, there is no internal appeals process. Even worse, if you're I'm sorry.
No, go on.
If you're denied a visa under that provision, they don't even have to tell you that that's the provision that they've used.
So you've gone under the Freedom of Information Act to find out what people they've excluded under that provision, and that was a year ago that the ACLU filed their first papers.
We did. We filed the request in March of 2005. After 7 months of not getting any response from any of the agencies, we were forced to file a lawsuit to force them to turn over the records. And I will say that the FOIA asked for information about how they're using this provision and some other immigration laws we thought they might use to keep people out for politically motivated ideological reasons. And the judge actually in January ordered the agencies to respond to the request. So we're slowly getting documents in.
But you're just beginning.
We're just beginning. But the other, aside from that, we decided, based on the statement that the government had made that they had used this provision against Professor Ramadan, we also filed a challenge on behalf of a number of organizations who had invited Professor Ramadan to speak to their members. And up until 2003, Professor Ramadan was here all of the time, speaking to very prominent, groups. Even the Bill Clinton's Foundation had invited him, I believe, in 2003 to come and speak. So we filed a challenge on behalf of those organizations because they're prevented. They have a First Amendment right to hear his ideas and engage him in debate. And we filed a challenge to challenge his exclusion as well as the constitutionality of that statute. And right now, a judge is hearing our challenge to Professor Ramadan's exclusion.
There are also some other noted people that you do know of. There was a Latin American expert who was denied her position at Harvard because she couldn't come back into the country.
Right. We don't know if they've used that provision, but there have been news reports that have suggested a number of prominent scholars have been excluded for what appear to be ideological reasons. Dora Maria Tellez is a good example. She was a very prominent member of kind of the overthrow of the Somoza government in Nicaragua, and was slated to teach at Harvard.
How long ago was that overthrow?
1978. You're testing me, Ronnie. But she unfortunately, she was supposed to go take some courses at the University of San Diego before assuming her position at Harvard. They denied her visa without explanation, simply saying it was because of some terrorist-related activity. You know, and there have been similar exclusions that just seem questionable.
So we don't really know. We don't even know what they're doing. I mean, no less whether the law is constitutional. You don't even know where to challenge, do you?
That's absolutely right. I mean, I think in the case of Professor Ramadan, one important thing to say is once we filed the lawsuit, I will say for 2 years after they revoked his visa, these statements that they had made about him endorsing, espousing terrorism, you know, circulated around the world. Organizations, editorial boards consistently asked the government to, you know,
show us the evidence.
Show us the evidence. Show us what you have. No one seems to believe that this man has endorsed or espoused terrorism. And only after we filed the litigation and they were forced to come into court to explain it, did they back off a bit. And they said, oh, we've never actually made a formal determination that he's endorsed or espoused terrorism, and we don't plan to do so in the future. And that's great, because obviously this, you know, the stigma that comes with...
So now, can he come back?
Not yet. He actually has a pending visa application that's been sitting for 7 months, even though it's supposed to be decided within about 30 days. Even the complicated security-related applications are. So one of the things we've asked the court to do is order them to act, and act quickly.
But excluding people because of their ideologies is really nothing new,
Certainly
right?
not.
We had the McCarran-Walter Act. Was that what the name, during the McCarthy era?
It was.
But there was a difference, wasn't there?
Well,
didn't they have to disclose why?
There is a difference. I don't know technically, but what often happened, there were these broad laws that pretty much excluded anyone that was affiliated with the Communist Party.
They come with waves of hysteria.
Exactly. It's always, you know, people, you know, they deem to be threats, you know, must be kept out, and then later on you find, obviously, that these people were never threats in the first place, and it really was just
I wonder
hysteria.
when we look back on the Bush administration, if we're not going to all feel the way we do when we look back on the McCarthy administration, you know, the McCarthy times. How did we let that happen?
I don't know. I mean, it's definitely, history is repeating itself all over the place, whether it's, you know, warrantless surveillance, this kind of hysteria about keeping foreigners out who might have ideas we don't like. It's troubling.
Let's talk about the warrantless. I mean, there's another aspect to the warrantless surveillance, which was the National Security Act, right? You go on, let's discuss that.
Sure.
The wiretapping.
Yeah, separate and apart from the Patriot Act, we've learned, which actually, just to say, it sort of makes the whole Patriot Act debate sort of silly, because the idea is we're at least having some public debate, you know, however lopsided, about, you know, what kind of surveillance powers the government should have. Yet we're having that debate, and
they have this.
They've
taken these powers.
Yes, all along, you know, President Bush has secretly authorized the National Security Agency to engage in extremely intrusive monitoring. Essentially, he authorized them to collect and monitor and often disseminate the telephone calls and emails, you know, made to and from U.S. persons to either allegedly, you know, suspicious people, or, you know, to particular geographic regions. And they're also engaging in kind of larger data mining practices. It seems that they're, you know, analyzing large streams of communications to try to create patterns to see what may or may not be suspicious. And all along, you know, while we're having this debate, you know, about the Patriot Act, this in many ways, much more intrusive surveillance has been secretly authorized without any public debate. And it's only because of, you know, brave whistleblowers in the National Security Agency that we know anything about it.
But I was struck with the awarding of the Pulitzer Prizes, that the 2 reporters from the New York Times won a Pulitzer for their reporting on this wiretapping. But they themselves had held it up for a year before they revealed it.
That's very true. And as I've said before,
another frightening thing.
It is scary. I mean, we see it a lot. There's a lot of, you know, brave reporters who are doing really great work.
Right.
You know, and Eric Lichblau and James Risen are among them.
Right.
But we're also seeing in a series, once the stories actually break,
they're the people who won the Pulitzer.
Right. Once the story actually breaks, you'll find, if you read the stories closely, they say, you know, we're actually still withholding this piece of information because officials have come to us and said there will really be some kind of national security harm if we disclose it. And it's a troubling trend. It's, you know,
it's a frightening trend, I think. I mean,
especially because one of the problems we've seen, especially litigating these cases over and over, is just these excessive claims of secrecy. And the government is making them to Congress, they're making them to the courts, and the only, non-branch left is the media. It's only up to the media, essentially, to report on what they find out about. So it's very important.
But we find that the media self-censors, listens to this and self-censors itself.
Yes.
Which there's no way of...
Yeah, there's no public value in that.
There's also no public challenge to that, is there?
No, I don't think people are really questioning it as much.
Yeah.
You bring up, that they kept it for a year. I don't believe anyone really talks about that anymore. And maybe it's because there's so many other troubling things going on that people just can't keep track of them anymore. But, it's definitely important for the media to be, much more, aggressive, perhaps, about reporting these kinds of things.
Well, I've always, we've talked about this before in the program. When I grew up, it was the fourth estate was to oversee the three different sections of the government. That was the people's surveillance in a way.
Exactly.
And if they don't live up to that, then we really can get sunk by it.
Yeah, we're really in the dark. And it's so important, people say the now more than ever a lot. And I think that what we've seen time and time again about the policies that are coming out of the Bush administration, one has to only think we know the tip of the iceberg. And the things that we actually learn about are very troubling, not just to the left, not just to Democrats, but to people, they're things that go right to the foundations of our constitutional democracy. And if we don't, stay vigilant and stay on top of it, they can really be eroded without any question.
Some of your cases will land up at the Supreme Court?
I think so. I think it's quite likely that the national security letter case will end up there.
What do you think, knowing the people on the court now?
Oh, I can never speculate. I can never speculate.
Do we speculate quietly in the office?
I think that the hope is, these cases, these national security cases that they have heard, the best example is Hamdi, the enemy combatant case, where a very strong opinion was written by Justice O'Connor that came out and said, the state of war is not a blank check for the executive.
What was that case?
That case was a challenge to holding enemy combatants in Guantanamo.
Guantanamo.
And the question was whether they had any legal rights to go to a court, to go to a court to challenge. They were being held there with no charge and often no access to counsel at all. And the court did issue an opinion that said, they have to have some legal channel here. And in the course of writing that opinion, Justice O'Connor, very strongly said there is a role for the courts in all of this, and state of war is not a blank check.
So what happened as a result of that case?
Oh, all of the Guantanamo things are still being litigated, throughout the courts. It takes
forever, doesn't it, to do this?
It takes a very long time. There's another case before the Supreme Court now that's specifically a challenge to the military tribunal process.
Right.
That's where a number of people are being tried, and it's a very constitutionally and deficient process, and the Supreme Court is hearing that now. I expect there'll be a decision in June, but that will be a very important decision. So all to say, I do hope, because these cases present really foundational questions, can the president disregard the law? The national security surveillance is the perfect example. There's a statute on the books that expressly prohibits anyone, including the president, from engaging in the kind of wiretapping that he authorized, and it's actually a crime. So they're very foundational questions, and I hope that the Supreme Court, any court, faced with those kind of challenges, will take them very seriously.
How does the Congress? How can the Congress challenge the president? Can it?
Yes, it can. It definitely can. Especially, using the NSA surveillance.
Yeah.
There's a law that actually says that the president has a duty to report, periodically about all of these intelligence activities, even covert. There are oversight committees that are supposed to be overseeing this. The national security wiretapping policy, President Bush says, well, I briefed, a small subcommittee of Congress.
He always is briefed.
Yes, right. But they were not allowed to tell other people.
They get gagged.
Exactly, they do. There's gags everywhere. Gags everywhere, unfortunately.
It's not funny. It's terrifying.
You can only smile about it without wanting to go home and cry.
You're working on another case which has this terrible name. Extraordinary, what is it called? Extraordinary rendition.
Yeah, this is actually my saddest case. They're all rather sad, but this one is just particularly sad because it's one of the few cases where I actually feel like it's not just kind of illegal, it's sort of immoral. Yeah. Basically, the policy of extraordinary rendition, as it's come to be known for reasons I don't understand, is essentially, if I could boil it down, the process of abducting people the government, typically the CIA, believes allegedly to be terrorism suspects in some way, abducting them either kind of capturing them inside or outside the United States, typically outside, and either transferring them to secret U.S.-run facilities, typically in Afghanistan or other places.
Do we know how many secretly run U.S. facilities there are?
That we do not know. Okay. There was a story by Dana Priest in the Washington Post that reported on these, what they call them, black sites. We don't know how many there are. There's a number of inquiries going on in Europe right now to try to get to the bottom of that, but it's widely believed that as soon as that story came out, a number of them closed down, so who knows. So they either transfer these suspects to U.S.-run facilities, or they transfer people, and the purpose of the transfer is for detention and interrogation, and quite often torture, because the whole purpose is to get people outside of a legal system. No court is ever involved in this. It's an executive decision. And they take them outside of U.S. law in order to engage in interrogation tactics that are not authorized here. So they either send them to the U.S. facilities or they send them to foreign intelligence services in other countries that are known to torture, such as Syria, Egypt, places like that. We represent a man named Khalid al-Masri who is a German citizen who was literally, this is going to sound fantastical, but it's sadly true, was on a holiday in Macedonia, was captured by Macedonian officials, held in a hotel for 23 days, at gunpoint, wasn't allowed to leave, incommunicado, couldn't speak to anyone else, and was essentially handed over to the CIA. The CIA drove him to what he was blindfolded, drove him to what seemed to be an airport because he heard airplanes. They beat him, they drugged him, they threw him on a plane, chained him spread eagle, to the plane. He was unconscious for most of it. He landed. He was taken out. He was driven, briefly to a holding facility where he was held for literally 4 months, a little over 4 months, in absolutely terrible conditions, putrid water, in solitary confinement for that amount of time, interrogated a number of times, very roughly. It was clear, the saddest part of the story is that there are news reports that 2 months into his detention, people actually briefed CIA Director Tennant, former Director Tennant, saying, we have an innocent man here. We have the wrong guy. And he was still held for 2 more months. He and other inmates in this facility engaged in a hunger strike for, I believe it was 23 days. And eventually he was let out. And the best part, if you could say best, is that, this whole time he's being held without charge, without, anyone knowing where he is, they decide to release him. But he's not released in any kind of normal way. Instead, he's driven through hills for 3 hours and literally dropped on a hill in Albania and told to walk down a hill. And he literally thought he was going to be executed. He's just told to walk into the night. But he was met by Albanian officials who eventually got him back to Germany.
So
it's terrible.
And he's back now in Germany.
He's in Germany now.
And you're suing. We have 3 minutes. I want to know how you got to be a constitutional lawyer. You've had to study the Constitution, obviously, over and over again. And what made you decide you wanted to do this?
It's just, even though I've just told all these depressing stories, it's really, for me, the most exciting and the most relevant kind of work out there. I've done a lot of different things. I've done things in, HIV, other kind of issue areas that mean a lot to me as well. But, these days, I feel like it's the national security work, the constitutional work, those kind of issues that are most under attack. And I felt it was most important for me to be doing work in that area.
And you found a home at the ACLU.
Yeah, it's a wonderful place to work. Really wonderful, fun people, smart people.
Hearing the cases, it's no wonder that the people who support the causes that you challenge are always challenging the ACLU, right?
That's true.
During the McCarthy era, all you could hear about was, well, that person is a subversive, they're a member of the ACLU, or they hold a card or something. So it's an astonishing thing. Yeah. But this, in the opinion of people who've lived through both of these things, and I'm sure you must have come in contact with them, this is far worse, isn't it?
It's, in so many ways, it's the same but different.
Yeah.
And to my mind, it's far worse. Just because, I think it's also because of the secrecy. I feel like, at least when other things happened before, there was still some mechanism to find out what was really happening. There was some level of accountability, and I think we have to get back to that place. And it seems so far away now. But I do believe that what's happening is just, you know, from torture and kidnapping people off the street. I mean, these are things that we don't want done in our name, and hopefully we'll stop.
Well,
soon.
it's just been a whole shocking thing.
Yeah.
In your lawsuit, let's go back now to the German citizen who was abducted. The lawsuit is directed against the government, against Tenet, against the CIA, against everybody?
It's actually against Tenet in his individual capacity.
Has he ever answered any of this?
He has not yet. They've actually, they're trying to dismiss the suit, essentially saying that everything that's happening, everything that the case is about is too secret for a court to hear it, and that it should be dismissed. So we're fighting that right now.
So it's this whole constantly reinventing. I mean, it's always too secret, so you can never get to any place.
Right.
It has to be an extremely frustrating kind of thing.
It is. It is.
But
we
it's
have
also
hope. We have hope.
You do have hope, and it's also wonderful that there are people who are challenging this like you. I think it's an incredible kind of thing, and I hope you keep doing it.
I'll do it as long as they let me.
And I hope people, I don't usually do this as fundraising, but people should send the ACLU some contributions so you can go on and do it. What's your next big case that comes up?
Well, we actually have a big argument in the Rendition case in May, hopefully convincing the court not to dismiss it.
The Rendition case being?
The Khalid al-Masri,
yes,
the German citizen.
Did his family got totally disrupted, didn't it? They didn't know where he was.
Sadly, his wife had no idea where he was and was forced to believe that he had left. But they're reunited now.
Well, hopefully we'll be able to read about it in the paper. There won't be a gag order, right?
I hope you'll see stories.
Thank you. Thank you, Melissa
Thank you,
Goodman.
Ronnie.
Thank you. If there are any people you'd like to hear and topics you'd like us to explore, please let me know. You can write to me at CUNY TV, 365 Fifth Avenue, New York, New York, 10016, or you can go to the website at cuny.tv and click on Contact Us. I look forward to hearing from you.